morning, everyone, and welcome to our webinar run by St John's, Chambers, Bristol and Bath firms Mogers, Drewitt and Roydsworthy King. I'm Amanda Noyce, partner of Roydsworthy King, and I head up our specialist contentious probate and contentious trust team. Today, I'm delighted to be hosting our webinar and welcoming our two familiar and wonderful speakers. Before I come to them, I'd like to say a few housekeeping points. One of the good things about webinars is that you don't have to hear endless rubbish about fire exits, but I do need to tell you about how to ask questions. You will see a chat facility on your screen. Do feel free, please, to type any questions into your chat, and there will be time at the end of our two speeches for your queries to be considered. In addition, there is a hand waving button on your screen. If you would prefer to ask your question out loud to everybody, please click on the hand button and our technical support will come to you so that you can ask the question on air to the wider audience. Please remember, though, to have your video and sound on so that we can see and hear you. There is also a poll facility on the screen, and I'll come to that in a moment. First up is Luke Watson, partner at Mogers Drewitt, who heads up that firm's wills and inheritance disputes team. Luke and I have been friends for over 20 years, and I've crossed swords professionally with him on a few cases, but we've never fallen out. I'm pleased to say that Luke will be talking this morning about the new statutory instrument, which is amending that a terribly current piece of legislation, namely the Wills Act 1837, and bringing it kicking and screaming into the modern world of videos and camera phones. This has proved a strangely controversial piece of legislation, but we will be asking you all to consider whether you believe that the legislation, set to last only until January 2022, should in fact be made permanent. Please use the voting buttons on your screen, and we will let you see the result of the vote at the end of the session. You can vote at any time during this webinar. Then we will, so now without further ado, I'd like to turn over to Luke. Thank you.
Thank you, Amanda. I'm just trying to get my slides up. Okay, whilst my slides should appear on the screen in a moment, they're not there at the moment. I'm sure the technical people will sort that out, so I'll start talking, everyone. So good morning, everyone. Thank you for attending this seminar. There we go. They are there. Perfect. It wouldn't be a video seminar if there wasn't some technical hitch. There we go. So good morning, everyone. Thank you for attending this seminar. I was thinking about my talk this morning when I was walking my dog in the sunshine, and some certain phrases came to mind. The new normal, Groundhog Day, purgatory, dystopian, strange times. These are all phrases that I've heard over the past 6 months as the human race has tried to make sense of the coronavirus pandemic. And this is the context within which the government has decided to change the law relating to wills. And it is also apt that I'm talking to you today about video witnessing of wills by way of video link. Now, there's been a lot of comments in the news over the past few days about this government's reliance on statutory instruments during the coronavirus pandemic. And it may not be a surprise that the Victorian piece of legislation, as Amanda said, the 1837 Wills Act, is being amended by a statutory instrument rather than an Act of Parliament. The relevant statutory instrument is called the 1837 Electronic Communications Amendment Coronavirus Order 2020. Quite a mouthful, and I would urge you to read it in full. It was laid before Parliament on the 7th of September and is due to take effect 21 days thereafter. As you'll see, when I originally wrote these slides, it was not yet law, but 21 plus 7 is 28, which means that the law came into effect yesterday, unless something peculiar has happened in Parliament that I wasn't aware of overnight. Now, the amendments being made pursuant to the Electronic Communications Act 2000, sections 8 and 9, if you want to read them. And therefore, the government believes it's this act which empowers it to lay this statutory instrument before Parliament. There has been some discussion amongst constitutional lawyers whether, in fact, this statute permits the government to do what they've done. and I will talk about that briefly later on. Interestingly, the statutory instrument has retrospective effect, and so it applies to all wills made on or after the 31st of January 2020 and on or before the 31st of January 2022. Now, the reason for the 31st of January 2020 is that that is apparently the date that the UK officially recorded its first case of COVID-19. And in addition, the sunset clause of 31st of January 2022 may yet be extended. The statutory instrument does not affect any grant of probate or anything done pursuant to a grant of probate prior to 31st of January 2020, which suggests that it therefore can affect grants of letters of administration made before the 31st of January 2020, but more on that later. As you will see, I've reproduced Section 9 of the Wills Act with the amendments made by the statutory instrument highlighted in red for ease of reference. I'm going to read subsection 2 to you. For the purposes of paragraphs C and D of subsection 1, in relation to wills made on or after 31st of January 2020 and on or before 31st of January 2022, presence includes presence by means of video conference or other visual transmission. So the key word here is presence. Now, the Ministry of Justice has been busy writing guidance, and I've reproduced the link to their guidance on the slide, as you will see. And it is important that everyone reads it. It's quite detailed. It's notable, I think, that the substantive changes to the law are quite minor, and this means that all the other formalities present in Section 9 still need to be complied with. And this means that it is not possible for a testator to direct another individual to sign the will on the testator's behalf in their remote presence. A testator can, of course, direct another person to sign the will on their behalf in their physical presence. Clearly, the testator must have testamentary capacity and be free of undue influence and know and approve of the contents of the will. And I'll talk a little bit later about some of the pitfalls associated with that. The Ministry of Justice guidance makes clear that wills should only be witnessed if physical witnessing is not possible. And when you look at the process recommended by the Ministry of Justice, as amplified by the STEP guidance, it seems clear to me that the potential for disputes is real. The remote witnessing must take place in real time. It must not be done by any pre-recorded video. And the best practice is to use a bespoke attestation clause. STEP have published some attestation clauses for their members. So, for example, it may be advisable to mention in the attestation clause that virtual witnessing has occurred, along with details of whether a recording is available. It's very important to record and retain the whole process in case of a later challenge. And there will be at least 2 videos. There'll be one video when the testator signs, and there'll be another video when the witness signs. And if the witnesses don't sign together, there will be a third video. So there's quite a lot of data to be recorded and retained in a secure way. So this means that we as practitioners need to think about the technology that we're going to use, and we need to make sure it's tried and tested. The will be traveling around quite a lot because it needs to be signed by the testator and then the witnesses. So there could be 2 or maybe 3 occasions. So there's a risk of the will getting lost, or a risk of the testator dying during the process, which could lead to an invalid will. The Ministry of Justice has decided that no counterparts are allowed. So the safe custody of the original during the signing process is absolutely vital. And as practitioners, we need to consider how physically the will be transported. Will it be courier? Will it be recorded delivery, special delivery? Will the nervous solicitor be driving the will around themselves to make sure it doesn't get lost? So what are the implications, some further implications of the Ministry of Justice guidance? Well, they recommend that at the beginning of the video, the testator makes a statement along the following lines. I, name, wish to make a will and sign it here before these witnesses who are witnessing me doing this remotely. If the witnesses don't know the testator, they should seek evidence of identity, such as a passport or driving license, which would need to be viewed on the screen. The signatures must be in ink. We are still at the stage where, even though we are having video witnessing of wills, we cannot have electronic signatures yet. As some of you may be aware, the Law Commission is currently undergoing a project in relation to wills following their 2017 paper, so electronic signatures may yet become permissible in the future. As I've already referred to, the best practice is set out in considerable detail by the Ministry of Justice. There are 4 stages, or 5 if the witnesses are not physically present with each other when they sign. I did consider reading the stages out to you during this seminar, but I think it's best if you read it yourselves. I thought it would be a little bit dry, and I would rather talk about the very old case law, which I'm going to talk about shortly. The fact that the staged process recommended by the Ministry of Justice is quite convoluted means that it'll be interesting to see how the courts view that guidance, and indeed the step guidance, and whether perhaps minor diversions from the recommended process could lead to clever contentious lawyers such as yourselves challenging the validity of the will. In my experience, challenges to professionally drafted wills based on Section 9 infringements are rare, but under this legislation, it seems likely that they may become more common. Witnesses should not only be able to see the testator, they should be able to hear them as well. And don't forget that acknowledgement of a signature is a permissible alternative if the actual signing is missed by the testator or by the witnesses, perhaps because the video link freezes or lags. So in practice, this means that if a testator's signature is missed, then when the video link is restored with both witnesses present at the same time, the testator can acknowledge their signature to both the witnesses once they are able to see and hear each other again by showing the completed signature to the witnesses on the video. And similarly, if the testator misses a witness signing, then when the video link is restored, the witnesses can acknowledge their signature to the testator in the same way. I've mentioned confidentiality on the slide and the choice of witnesses, and that's very important that the testator and the professional advisors consider carefully who the witnesses should be, and I'll talk a little bit more about that later. I've also reproduced the step guidance on the slide as well, so you can look at that, and I would urge you to read that as well. Now, what's the Ministry of Justice's views on the existing law? Well, they've reproduced 3 scenarios, which in its view would lead to a properly executed will during the coronavirus pandemic without the use of video witnessing, provided that the testator and witnesses all have a clear line of sight. And I'm sure many of you watching this today will already have used some or indeed all of these methods. And those 3 scenarios are as follows: witnessing through a window or open door of a house or vehicle, witnessing from a corridor or adjacent room into a room with the door open, witnessing outdoors from a short distance, for example, in a garden. Now, the Ministry of Justice takes the view that these scenarios are consistent with the existing case law, and that video witnessing under the current case law would not lead to a validly executed will. But that's actually a view that is not uncontroversial. And I'm now going to talk about whether the legislation is actually necessary, and whether in fact you could have video witnessing of wills under the current law. Remote witnessing is permitted in other jurisdictions, New York, New Zealand, Australia, Ontario, for example. And the reason why the Ministry of Justice has contended that remote witnessing was not permissible under the current law is because of the requirement for both witnesses and testators to have a clear line of sight. However, there's a body of case law which regarding the meaning of presence, which suggests that video witnessing could fall within that definition of presence if a clear line of sight is established, albeit remotely. I'm going to talk you through some of those cases now. First is Casson and Dade. Now, after all this talk of statutory instruments that came into force yesterday, it will be a relief to Chancery lawyers that a Georgian case remains good law. And I will also refer to the case of Shires and Glasson, which is a case that was heard when James II was on the throne. So proper cutting edge stuff. In Casson, the judge said the following: Honora Jenkins, having a power, though covert, to make a writing in the nature of a will, ordered the will to be prepared, and went to her attorney's office to execute it. Being asthmatical, and the office very hot, she retired to her carriage, as we all do, to execute the will, the witnesses attending her. After having seen the execution, they returned into the office to attest it, and the carriage was put back to the window of the office, through which it was sworn by a person in the carriage the testatrix might see what passed. Note the use of the word might. Immediately after the attestation, the witnesses took the will to her, and one of them delivered it to her, telling her they had attested it, upon which she folded it up and went and put it into her pocket. The Lord Chancellor inclined very strongly to think the will well executed. Now, Honora's maid gave evidence that at the moment the witnesses were signing, the carriage horses reared up, causing the carriage to move into a line of sight with the office window. The maid stated that had Honora looked through the window, she could have seen the witnesses sign, and this was considered to be sufficient by the court. Indeed, Casson and Dade was applied by Senior Judge Lush in the Court of Protection in Re Clark, a case from September 2019. And in this case, Senior Judge Lush said the following: I am also satisfied that Mrs. Clark signed the LPAs in the presence of the witness, W. Even though he was sitting in the adjacent room, there were clear glass doors with Georgian bars between the two rooms, and he had a clear line of sight through those glass doors. Equally importantly, although we cannot know for certain, because she is not competent to give evidence on this point, Mrs. Clark would have been able to see W witness the LPAs by means of the same line of sight through the glass doors. I have no difficulty in relying on a very old legal authority like Casson and Dade. The fact that the judgment is over 200 years old simply means that it is basic common sense and has stood the test of time. Casson and Dade was also applied in Cowser and Cowser, a 1996 case, in which it was said that a valid acknowledgement of a signature under the Wills Act required that there should be at least possible visual contact. Now on to the 1687 cutting law case of Shires and Glasson. And in this case, a will was attested by witnesses in a second room, visible through a broken window, through which the testator could have seen the witnesses if he had chosen to look. And this was held to be a validly executed will in accordance with the statute of frauds. And the policy behind this decision was that the requirement for witnesses' will to be witnesses is to prevent someone obtruding another will in the place of the true one. Brown and Skirrow is a modern case because it's Victorian, from 1902, or was that, or nearly Victorian? Perhaps just I can't remember exactly when Queen Victoria died, so it's just on the cusp. And in this case, the will wasn't actually valid, but it was held in this case that presence means visual presence. And what happened was the testator signed her will in a busy shop, and one witness, who was the grocer's assistant, saw her sign, but the other witness, who was the grocer himself, was at the other end of the shop having a discussion with the salesman at the time that the testator and the grocer's assistant signed the will. There were also customers in the shop, and they were between the grocer and the testator when she was signing her will. The grocer did then sign the will at the testator's request. And Mr. Justice Gorrell Barnes said, "You cannot be a witness to an act that you are unconscious of. Otherwise, the thing might be done in a ballroom 100 feet long and with a number of people in the intervening space. In my view, at the end of the transaction, the witness should be able to say with truth, I know that this testator or testatrix has signed this document." So in this case, the will had not been properly attested, even though the testator had acknowledged her signature to the grocer, because that acknowledgement needed to have taken place in the presence of both witnesses before they each attested it. And finally, I'm going to talk to you about the case of Newton and Clark. This is an interesting case because it appears to run contrary to the case law that suggests that that presence means a visual presence. Now, the will was signed by the testator and attested by the witnesses who were all present in the testator's bedroom. Now, the testator obviously had a very large bed because the testator was lying in bed, but the curtains were drawn at the bottom of their bed. One of the witnesses and the testator could not see what the other was doing, although both witnesses were in close proximity and they could hear what was going on, even though they couldn't see what was going on. And the will was upheld. Being in the same room and within hearing was sufficient to establish presence. The object of the Wills Act was to prevent the substitution of another will so that no fraud could be practiced on the deceased. And the court commented that the doctrine of what it called constructive presence had been taken to great length in cases such as Casson and Dade. So a very interesting case that does seem to me at odds with the other case law. And so the conclusion, I think, is that it's certainly arguable, based on the existing cases, that remote witnessing via video link is in fact already possible under the current law, if a line of sight is established, meaning that there has been visual presence. And this applies even if it seems improbable that the testator actually saw what was going on. But the purpose, of course, of the statutory instruments is to remove any doubt on this issue. So what about avoiding disputes? STEP has helpfully published some recommendations as to how disputes can be avoided. STEP suggests that both witnesses should be lawyers if possible. It also suggests that the video witnessed will should be re-signed and witnessed by conventional methods as soon as possible. Now, clearly that's not going to be practical in lots of cases, otherwise you wouldn't be engaging in video witnessing in the first place, presumably. STEP has suggested that both witnesses should be in the same location, even though, of course, as you will see when you read the Ministry of Justice guidance, both witnesses may not actually be in the same location. It may be a three-way video link, and therefore the witnesses may be in a different location. But I think STEP thinks it's best to have the witnesses in the same location, both when they're witnessing the testator's signature and when they are signing themselves in the testator's presence, simply because it reduces the delay, and therefore delay can cause problems, as I've already mentioned. STEP also suggests that the testator and the witnesses should consider signing each or initialing each page as well, so there's no doubt about the document that is being witnessed. And finally, in addition to recording the whole process, STEP recommends practitioners taking very detailed attendance notes, which I think is clearly very important. I've talked earlier on a little bit about confidentiality in relation to witnesses. I mean, clearly there are issues because the witness is going to be able to read the whole will. Normally, if a witness witnesses a will, they're normally just shown the last page and they don't actually see the contents. But of course, if the actual will is being sent to them so that they can attest it, they're going to be able to read the will. So I think questions or consideration needs to be given to who the witnesses are. You wouldn't want disappointed beneficiaries to act as witnesses because they could clearly try and interfere with that process. They could, the will could become lost, as it were, or one of the witnesses may try and coerce the testator into changing their mind and executing a new will. Consider how to deal with testamentary capacity. Allow some extra time for that process. I mean, STEP has recommended 2 lawyers being witnesses. If there's any concern about testamentary capacity, should in fact one of the witnesses be a medical practitioner? What about undue influence? Is the testator alone? Are there other individuals audible in the background? Is it possible to see if anyone else is in the room with the testator? These are all things that need to be considered in advance and considered very, very carefully, and detailed attendance notes need to be kept by the lawyer, assuming they are one of the witnesses. Anomalies. As you will see, I've reproduced section 3 of the statutory instrument and also the explanatory note that appears at the bottom of the statutory instrument in the slides. So section 3 doesn't apply to grants of letters of administration, and thus it appears that a grant made pursuant to an intestacy could be set aside if a will witnessed by video was made after 31st of January 2020 and becomes valid due to the retrospective change in the law. And what about grants of letters of administration with the will annexed? How should they be dealt with? Perhaps if the courts adopt a purposive interpretation, it will allow such grants to fall within this saving provision. But this is not clear, and we'll have to see what approach the courts take if and when any cases come before it. I'm not sure I understand the purpose of section 3b, because if a grant of probate is valid, then surely everything done pursuant to it would be valid in any event, or perhaps it's just to add clarity. It seems to me that cases covered by the saving provision will be quite rare. But what about beneficiaries who've already had money under the intestacy rules, and then there's a later video will? What happens then? Do the beneficiaries have to pay that money back? As I've said, the statutory instrument is retrospective, and some commentators think that this could, due to the wording of the electronic, I've said electric there, I mean Electronic Communications Act, lead to an ultra vires challenge. Well, I'm not a constitutional lawyer, and that's a whole topic in its own right, but sort of watch this space to see if there's any interesting challenges brought. Questions can be asked via chat, so please do ask questions and we'll try and answer those at the end. And now I'm going to move over to Oliver, who's going to talk about the cheery subject of burial disputes. Thank you.
Yeah. Thank you. Thank you, Luke. That was very interesting. Next, as Luke has indicated, we'll be hearing from Oliver Wooding of St John's Chambers. Oliver is always a pleasure to listen to and has chosen quite a gory subject this morning: burial and funeral disputes. My team has had a few of these, but they are not common in my experience. It might surprise some of us how emotional people feel about a dead body, but such is life, or even death. I do love a good epitaph, though, like this one on a grave in Huddersfield. Here lies the grave of Emily White. She signalled left and then turned right. But seriously, Oliver is described in Chambers UK 2020 as a master at putting the client at ease and explaining complex issues in clear layman's terms. So I hope he will be putting that somewhat surprising area of law into simple language for us this morning. Over to you, Oliver. Thank you.
Thank you very much, Amanda, and good morning, everyone. Thank you very much for coming today.
Can't hear you.
Can you hear me now?
Yes, we can't quite hear Oliver at the moment. I'm just going to ask technical support just to make sure that we can hear him. So hold your horses for a minute, Oliver, please.
All right.
Thank you. Can you hear me now? Can we hear you now, Oliver, please?
Can you hear me? Yes or no?
Yes, I can hear you loud and clear now.
Excellent. Well,
yes.
thank goodness I went to the effort of putting on the very large headphones with a large microphone. It seems like it has worked extremely well there, and definitely one to practice and carry on doing for remote calls in the future. Anyway, there we go. Thank you all for coming today. Going to try and tackle this area, which is often lurking in the world of contentious probate practice, but doesn't often get the focus that perhaps it might do. Amanda's very kindly said that it's a rather gory topic. Well, I suppose it can be, but you'll be pleased to know there's no pictures on the slides. I'm afraid it's, from a chancery practitioner's point of view, just text. After today's talk, hopefully what you should have is an overview of what kind of disputes arise, how you can take steps to act on behalf of clients who either agree or disagree with the proposed steps that are going to be taken, and what the relevant considerations that the court will take into account in making its decision. We've got 20 minutes or so we'll take it at a relatively quick speed. So we start. Funeral and burial disputes. Well, what are they? Well, in my experience, they are an extension of contentious probate in its purest sense. That is to say, they have an emphasis on being contentious, but they tend to cover a wide range of matters. In the same way that we have disputes and are familiar with dealing with disputes over wills or gifts made in lifetime, matters that are relevant to funeral and burial disputes usually have their genesis in events during life. To that extent, there is going to be a degree of familiarity of wading through what your clients say happened during the deceased's life and expression of wishes and things like that. But what happens, of course, is the death is the trigger for the funeral and or burial, and often the trigger for the dispute that is going to be coming your way. It is rare, certainly I haven't been able to find an example of a prospective funeral and burial dispute. So we're looking at events that happen after death. What do they cover? Well, a wide range of things. Timing, how soon should the burial or funeral take place? Location, both as to the country of the ceremony, and we'll look at some of the authorities on that, or the location within the country, or the location of the facility, whether that's religious or otherwise, or the resting spot, whether that's for ashes or for where the grave should be and the burial takes place. Manner and method, so that deals with examples of a contest between whether someone should be buried or whether someone should be cremated. The type of service, who should conduct it, where it should be conducted. Cost, again, we're all familiar with funeral expenses coming out of the estate when we look through our estate accounts, but funerals can cost quite a lot of money, and some don't cost a lot of money. That is also something that comes into account. Who's responsible? Which family member or someone who's not a member of the family gets to have input, who gets to take control, who gets to make the decisions, and what do they need to take into account, and what can they legitimately exclude? Who gets what afterwards? Thinking here particularly about the division, if there is to be one, of someone's ashes, or maybe it's the wording of the gravestone, as Amanda said earlier, all those kind of things. So funeral and burial disputes is quite a broad topic, and it covers all or many of each of those points. Why do we care? I don't mean to be unduly facetious or trite, but I think it is worth focusing on this briefly. There's a deep answer and there's a practical answer. The deep answer is this: we spend a lot of time as litigators, and particularly litigators focusing on contentious probate matters, boiling down probate disputes to matters of money, to matters of cost and benefit analysis about whether you should take a particular step or not in the process of litigation at all stages. And we do try very hard, I'm sure, not to lose sight that there is, at the start of all this, the death of a family member related to the client, or with whom our client or the other side have an interest in. And we are quite familiar with that. But funeral and burial disputes are part of that, but they're also, I would suggest, slightly different. They're one of the few aspects of the probate process which has a legacy or a long-lasting ramifications, whether it's from historical or cultural matters, that is different to simply the finality that comes with agreeing a Tomlin order or getting judgment on a particular probate matter. So it is a matter that clients do care about. It's a matter that we should care about, and it's a matter that is slightly different, I would suggest, from the usual way in which we approach contentious probate matters. And of course, that's the deep answer. There is, of course, the practical answer, which is this. Funeral and burial disputes, in my experience, tend to happen in one of two places most often. The first is it happens at the very start, so at the time which leads to your initial instructions and getting to grip with the case. That's because, of course, the death is the death is the trigger. Excuse me for one moment. I'm just going to go and turn a telephone off that seems to be ringing in my room. I'll be back shortly. There we are. That's a reminder that if you do have questions, you can use the chat function. You don't have to ring into Chambers to ask them to me, but there we go. They happen, funeral and burial disputes happen in one or two places. One at the very start. So there is the death of the deceased and all the consequences, emotional and legal and practical, that arise out of that. So you may find yourself being instructed very rapidly because dealing with the body and what happens next is the first thing on people's minds. And as we'll see from the authorities, it doesn't require necessarily a grant of probate or any of the other legal documentation that we're familiar with. The alternative, I tend to find, is that it happens at the very end of disputes. And I think we all have experience of mediations or contentious probate matters where you're just about there, and it's 6 o'clock on a Friday, and you've been stuck in front of Zoom for, at that point, 10 or 11 hours, wondering whether or not this is ever going to end. And just when you're lining up the agreement to sign on behalf of your client, someone just says, "Oh, what about the ashes?" In the same way that they often say, "What about chattels?" So again, we need to be familiar with the procedure and the law behind it so that we can deal satisfactorily with the issues that our clients raise. So where do we start from? We start from the authority of Buchanan and Milton, which was a judgment of Mrs. Justice Hale, as she then was, and restates the principle about who has the right to the body. And from that, everything else flows. The point, the simple point is this: there is no right of ownership in a dead body, but there is a duty of common law to arrange for its proper disposal. And that is a duty that falls primarily upon the personal representatives of the deceased. So you may end up talking a lot with clients about who has the right to the body or where the body is or how to secure it, but that's not necessarily the way the court is going to look at it. The court is going to look at not where it is, but what happens next. And there is also a distinction between the position of an executor, whose title derives from the will, and of an administrator, who will need to go and get a grant of letters if they are to have the authority to be able to, on behalf of themselves as the personal representative, take the decision as to how the body should be properly disposed of. That is the framework, the prism around which the courts tend to assess these types of claims. It's not looking necessarily at what is the right answer for a decision by the court, but it is preferring the options put forward by those who at law would be entitled in order to take the decision themselves. So you have a client and they don't agree with what is being proposed by someone who might otherwise have the right to direct the proper disposal of the body. Well, what can you do about it? There are 3 separate bases upon which the court can intervene. The first is the inherent jurisdiction of the court. This has been floating around in the background in the authorities, but was stated expressly by Mr. Justice Voss, as he then was, in 2017 in the authority of Oldham Metropolitan Borough Council and Macon. Now, that is better known as being a decision that deals with the disposal of the body of the late and notorious Ian Brady. What Mr. Justice Voss said is this: in my judgment, the court does have an inherent jurisdiction to direct how the body of a deceased person should be disposed of. The court will normally, as I have said, be deciding between the competing wishes of different sets of relatives and will only need to decide who should be responsible for disposal rather than what method of disposal should be employed. I cannot see, however, why the court's inherent jurisdiction over estates is not sufficiently extensive to allow it, in a proper case, to give directions as to the method by which a deceased body should be disposed of. In my view, it is. So, if there is insufficient time to be able to draft something with the speed that you need to do to raise this point with the court, you can always throw yourself at the mercy of the inherent jurisdiction of the court. The second basis, and perhaps Mr. Justice Voss was referring to this, or perhaps it's separate, but certainly the authorities have looked at it separately, is the supervisory jurisdiction in relation to the administration of the estate of a deceased person. So again, we are, I suppose, quite familiar with making applications by way of a Part 8 claim form under the provisions in Part 64, asking for the court to give an answer about a question that deals with the administration of the estate of a deceased person. A question or an answer that is needed to deal with the disposal and proper disposal of the deceased person's body is absolutely a question that arises in the administration of the estate of a deceased person. So you can make an application on this basis as well. Again, in my experience, this is a particularly relevant method if you have circumstances where there's no dispute about who should be responsible for the body, for the disposal, but there is a dispute about what they should be doing about it, often seen in circumstances where there is probate has been granted to independent administrators or executors. And the third, and perhaps the most common, certainly from the authorities' approach to dealing with this matter, is dealing with it under Section 116 of the Senior Courts Act 1981. Now, Section 116, when we give seminars and webinars about its effect, is usually discussed in the context of making applications to remove personal representatives from their position. Section 116 is the method you can use to pass over someone who would otherwise be entitled in favour of someone who's lower down the list of persons that the court would be interested in. And it can be engaged where it is necessary or expedient to do so, and there are special circumstances that justify that necessity or expediency. The point of a Section 116 application is that it leads to the grant of probate. So this goes back to the analysis that was set out by Mr. Justice Hale, that the court is often choosing between who it is that should have the responsibility for disposing of the body rather than making the decision itself. Now, interestingly, when we do talk about Section 116 these days, we tend to say, oh, what about Section 50 of the Administration of Justice Act 1985? That is often a more convenient and quicker way of dealing with an application for the removal of a personal representative. And in my experience, particularly now it's been clarified that you can use a Section 50 application prior to a grant of probate, the more common way of doing it. But bear in mind that the test under Section 50 is ultimately what is appropriate in order to ensure the welfare of the beneficiaries above all else. The welfare of the beneficiaries is not necessarily the answer to the question of what is the right and proper way to dispose of a body. Whereas under Section 116, the circumstances that are going to be considered special are far broader than just the welfare of the beneficiaries. So if you're going to make an application to remove, which is the underlying purpose of which is to ensure the proper burial of the body in the way in which your client wants, then Section 116 rather than Section 50 is the way forward. Finally, what can I do if I don't agree for injunctive relief? There is, by necessity, as a result of the timelines involved, and despite advances in medical science, the ultimate deadline by which a funeral director can only look after a body for a certain period of time, or at least at a certain period of time for a reasonable cost, a degree of urgency, which means that the decision needs to be taken in an appropriate and rapid way. More importantly, if there is to be a dispute and you are acting for the person who disagrees with what is being proposed, there is usually something that you need to stop from happening, whether it's a ceremony, whether it's a funeral, or whether it's plans for a ceremony or a funeral that your client disagrees with. The only way in which that can be done effectively is to apply for injunctive relief. The test for the grant of an interim injunction in relation to a funeral and burial dispute is no different to that usual interim application for injunctive relief. It's the American cyanamid test. But it does place a great deal of practical matters on you as the solicitor or counsel dealing with these disputes, because you need to have all your ducks in a row quickly in order to make that application, in order to get the remedy that you need to hold the ring, as we say, pending a final determination. These are matters that are often, if not usually, dealt with by the interim applications court. And they are sometimes matters where the urgency is such that it may mean that you have to apply it without notice, with all the additional obligations that brings upon legal representatives to draw to the court's attention matters which may not be in their favour. If in doubt, check the Chancery Guide and read it again and again. Those are the bases on which the court can intervene, but how is it going to do so, and what factors are it going to take into account? There is one overriding factor to which all authorities since 2008 have pointed back to and repeated again and again and again. It is the overriding factor that Miss Sonia Proudman, sitting as she was then as a deputy High Court judge, set out in Hartshorn and Gardner. It is that the body be disposed of with all proper respect and decency, and if possible, without further delay. And again, in my experience, there is as much emphasis on without further delay as there is respect and decency. It is unusual in my experience for the competing obligations or competing propositions between people who disagree about what to be done, that one is a matter that involves respect and decency and the other one that does not. It is usually a matter of timing and balancing two perfectly plausible alternative approaches. That test has been set out. It's been adopted in at least two other cases, in fact, more than just those two there. And it is what we must bear in mind at all times when we look at the other factors for consideration. The other relevant factors have been listed primarily in Hartshorn, but also in the Oldham cases as follows. The first are the deceased's wishes. The second are the reasonable requirements and wishes of the family who are left to grieve. The third is the location with which the deceased was most closely connected. And the fourth, again, arising out of the Brady case, is that the public interest is also a relevant consideration that the court will take into account. Now, those are, in the same way that we have to try and advise clients about making 1975 Act claims, very easy to state as to what the factors are. But of course, the real meat of it is how they are to be weighed up by a judge on any particular application. To that extent, particularly in funeral and burial disputes, these are fact-sensitive cases. You will have to assess and analyze and make your own decisions about which you think a court is going to put greater weight on and whether the evidence substantiates it. And of course, going back to the point about urgency, the less time you have in order to do that, the more difficult it may be to persuade the court of the validity and the weight that should be given to an objection that's being put forward by your client. Perhaps the easiest way of providing some degree of examples are to look at three or four of the authorities and just set out what factors were taken in there and the conclusions that were drawn. So these are the authorities that have been referred to in the slides previously, but there are particular slides that set out the content. So the first was Buchanan and Milton. That was the decision of Mrs. Justice Hale, as she then was. This involved a situation where the deceased was an Australian Aboriginal who was born in Australia but brought up in England by her adoptive family, and she died in England. The dispute between the competing proposals was between her natural mother and her adoptive mother, who also was supported by the mother of the deceased's minor daughter. The natural mother argued that the cultural heritage and the need for proper burial proceedings that arised out of the heritage as an Aboriginal was such that it justified, and only justified above all else, repatriation to Australia, so that the funeral and burial could take place in accordance with those requirements. The natural mother also said that it was important for the deceased's daughter, who also shared those values. But the decision of Mrs. Justice Hale was this. She accepted that these were special circumstances that could engage Section 116, but she didn't agree that it was necessary or expedient to effectively pass over the adoptive mother and family who proposed to bury and dispose of the body properly in England. She emphasized that the role of the adoptive family was such that it required a great deal of weight to be placed on it, that the needs or desires or the welfare of the minor daughter were not in the context of this application, as opposed to an application in the family court of paramount value. And that the cultural heritage argument was something that the court could not prioritize above and beyond any other wishes or feelings supported by cultural backgrounds that the deceased may have. All of those pointed, therefore, to dismissing the claim under Section 116 and effectively permitting the adoptive family to arrange for and organise the burial. The second case we looked at was Hartshorn and Gardner. There was a decision of Miss Sonia Proudman QC. This involved a deceased adult son, and the dispute was between mother and father. The dispute was quite local, as it turns out. It was involving two villages in Wiltshire, about 40 miles apart. One was where the deceased lived with his fiancée, and it is where his father, the deceased father, said he should be buried. The other was a village where both the deceased father and the deceased mother, who had separated, lived. And that is where his mother said he should be buried. The decision of the court on that basis was that they went to where the father suggested, which was where the deceased lived. On the basis that that was the area that he was most closely connected to. He lived there, his fiancée lived there, his brother lived there. It outweighed the difficulties that his mother had, and the court accepted, in making that journey of 40 miles to go and visit her son's grave or the burial plot, which were real, but in the event outweighed by the other considerations. Anstey and Mundell is a decision which we saw adopted the principles set out in Hartshorn and Gardner. This was effectively a competition between whether or not the deceased should be buried in Jamaica or in England. The deceased had been born in Jamaica, had moved to England when he was younger, and ended up living and dying in England. Two of his daughters said he should be buried and effectively repatriated back to Jamaica. Another daughter and a niece said no, he should stay in England. The decision of the court in that instance was that, in fact, he should be repatriated to Jamaica. That was, the court found, what the deceased wished through expressions, not in the will, but otherwise. It meant that he would be able to be buried next to his mother. And the court placed as much weight on what the deceased's extended family, so his network of more remoter family members and persons who were not natural members of the family but were close to him, wished, and they all pointed in favour of Jamaica. And that was sufficient to surmount the obstacles, the practical obstacles that would be put in place in trying to repatriate from from England to Jamaica. The final one that we looked at was the Oldham case, the one of Ian Brady. This was a decision that was ultimately taken under the inherent jurisdiction and Section 116. There was no need to dispose between them. And the point there is that there was a public interest in making sure that the burial was conducted in a suitably sombre mood, and not how the deceased, the late Ian Brady, wanted, which was designed to cause upset to the families of his victims. And that overweighed everything else. The reason why the public interest has more weight now is obviously in circumstances of the current pandemic, there is something more of an interest in quite how effective and efficient the funeral and burial disputes need to take, or funerals and burials need to take place in order to comply with the various regulations we find ourselves under. So that's 4 examples that give an idea of how the court deals with the matter. I just want to finish by dealing with 3 points of miscellany that come up. Ashes are not chattels, but they are often treated as if they were. This goes back to the point about mediation. Ashes technically belong to the personal representative, but the proper disposal of it usually means some form of division or agreement between competing family members. A good litigator and a good mediator, if you get there, will usually be able to find a solution, most likely by dividing as necessary the ashes, or come to some form of agreement. But that comes up time and time again in all contentious probate matters. Secondly, funeral directors are wearingly familiar with these kinds of disputes. It is very likely that in any of these cases, if you're going to bring one or if you're going to defend one, you are going to have regard, and the court will have regard to what the position is on the ground and what the funeral directors can and can't do, either at all or are willing to do. They are, in my experience, surprisingly familiar with the ins and outs of these kinds of disputes. They are usually quite patient in doing nothing and waiting for the court to give direction, and usually helpful if you have any particular questions about the practicalities of preserving, for example, a body whilst the outcome is pending. And finally, just a little bit of trivia. There are situations where the disputes might still come up considerably after the burial has taken place, or it may be necessary to exhume bodies for other purposes, whether it's DNA testing or likewise. Do bear in mind, you need to get a license for exhumation. You can download a form for the Ministry of Justice. It seems quite a prosaic way to deal with a matter that can be so emotionally demanding. So there we are. That's covered at a relatively quick speed. I hope we've got enough time for some questions, and I'll hand back to Amanda.
Thank you, Oliver. That was absolutely fascinating. Please do chat in your type in your questions into the chat, everybody. I've got one question from David Wild, and this was in relation to section 116, and he asked whether it would make a difference whether someone has already intermeddled. Could you still appoint him under section 116? What do you think, Oliver?
I think it's a relevant matter, and the way in which the intermeddling took place is going to draw the court's attention. If you have someone who's intermeddled deliberately to try and put the stop on someone else from obtaining the grant on the basis that, having said that they're intermeddled, they're going to be required to take the grant, then I think the court will look quite disapprovingly on that. If you've got someone who has intermeddled because they were under the impression that there wasn't a problem and suddenly now there is, then I think the court will be quite sympathetic to it. So I think it's just it's not a determinative point, but it will be a factor to take into consideration and things like that.
And Victoria Grogan's given a fantastic question. What's the strangest funeral request you've ever encountered, Oliver?
I'm not, well, people don't tend to make requests to me to bury them. I think it's the first point to say. I haven't really had anything that I would say that was particularly strange. The difficulty, I suppose the strangest thing that has happened that related to a funeral is when persons have kept on the basis of future needs for DNA testing items. So other people may have had this as well, but I've certainly had papers and instructions that come with false teeth in plastic bags for the purpose of preserving future evidence, notwithstanding that the body's otherwise being cremated.
Wonderful. And John Kilmister's asked a very pertinent question. Can executors be liable if they fail to follow the deceased's burial instructions as set out within the will? I've actually come across this a few times myself.
Well, I'll let you answer then, Amanda. I think that's probably
well, technically, no.
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 I think I can't see how there would be any formal liability that gives rise to a direct, in the same way that we talk about kind of devastavic claims against executors in that way. If they are failing to follow what are obviously very sensible instructions, which have no difficulty being implemented and which represent, and everyone agrees, because the will is valid, the deceased's wishes, then their failure to do so is clearly not going to look good if they're trying to defend either an application for directions as to the burial and disposal by somebody else, or an application for their removal.
Good. And what do you think of the speed at which these disputes can progress? Presumably, in certain cultures where you have to bury the dead within 3 days, like the Jewish culture or the Islamic culture, how quickly can you get these things sorted?
I suppose it depends on how willing we are to work through the night, if necessary. How long does it take to draft a claim form and issue an application? I mean, it can be done extremely quickly if it has to be done. It is one of, again, as contentious probate lawyers, we don't tend to spend a lot of time doing urgent interim applications without notice in the same way that you do for media or defamation if you're trying to spike a story in the Sunday Times or things like that. But it can be done as quickly as it needs to, as long as you've got sufficient evidence in order to support your claim and get one on the balance of convenience. But generally, the closer you are to the event which you want to prohibit, the more difficult it is going to be to persuade a court that the reasons for disrupting or prohibiting it outweigh the factors we were looking at earlier about not dealing with matters with any unnecessary delay.
Okay, and Paul Walsh has given a question. I'll have to come to one for Luke in a minute, but I just these people are, you've obviously caught the imagination of our audience. How do courts approach the issue of costs in these type of cases?
Grumpily, generally, is my experience, because courts don't tend to enjoy having to deal with these matters, because they rather tend to think that they should be dealt with properly. No, seriously. They fall into two categories, mostly into the former matter. If there is a clear dispute between two parties, then this is hostile litigation between party A and party B. And the idea that the costs will come out of the estate is very unlikely to happen. You're looking at inter parties cost order, and that's something that you have to take into account. The tends to be exceptions in situations where, and again, we're talking about kind of Part 64, where there isn't a discrepancy between, there isn't a dispute about who should do it, but there is effectively a kind of neutral person putting forward. I've certainly been involved in this situation, a neutral executor putting forward the competing interests of one set of beneficiaries and the other set of beneficiaries, and saying, well, look, we need to resolve this. There's obviously a dispute here, and I'm effectively giving up my discretion to the court, so that whoever is disappointed is not going to be disappointed in me as the executor taking the decision. They're going to be disappointed in the court, but so be it. In those circumstances, costs did come out of the estate, but ordinarily I would say this is hostile litigation.
Right, interesting. Now, turning to Luke, how can you avoid the document going from person to person, particularly in times of COVID, and whether you've got a few virus and germs on the actual paper? One way I dealt with it in my firm is we actually had the document with the witnesses, one of whom was a solicitor, and he witnessed, but he also signed on behalf of the testator, and the testator by video link acknowledged that signature on his behalf. Do you think that would be a valid witnessing under the new legislation, or indeed under the old case law, Luke? What do you think? Can't be. Luke, I think you need to unmute.
I do. Sorry. I'll start again.
Sorry. Could you just start again? Thank you.
I am. Yeah. I think certainly under the case law as it exists in terms of physical witnessing of wills, I don't think there's any preclusion on a witness also signing the will at the testator's direction. So I think under the current case law, that is with physical witnessing, certainly that is fine. With video witnessing, it seems to me that the legislation, I mean, there was commentary about whether or not the statutory instrument would actually expressly allow this to happen, so that you have, so that the testator could be sitting in one room and over a video link with the witness saying to somebody else, you can sign that on my behalf, as it were, and that was not included in the legislation, I think deliberately, because it was talked about, certainly. So if you were in a situation, I suppose, where you'd probably have to have the testator and one of the witnesses physically present together under the existing case law, because otherwise under the statutory instrument it hasn't been allowed. And I think if the government wanted to allow it, I think they would have done, and they deliberately didn't. And certainly in other jurisdictions it is possible to do that. So when the government was looking at this legislation and other sort of Commonwealth and American jurisdictions, it is allowed in some of those jurisdictions, and the decision was made, rightly or wrongly, not to include it in the legislation. So I think the answer is I'm not sure. It would be an interesting one, but it would probably be but it could be a bit risky, I think. I mean, and that sort of ties in with, there's a question from David Wild about witnessing by video link, and does each party have to sign independently in each location? Well, I think the best practice certainly is that both witnesses should be present together. So probably best practice would be that you have the lawyer who actually drafted the will and someone else from their office actually in the same place witnessing the testator's signature, and then subsequently when the testator has to then witness those witnesses' signatures, then the witnesses should again be in the same place, if that makes sense. So there'll be 2 videos with the testator in one place and the witnesses in another place. Unfortunately, because no counterparts are allowed, there's no simple way of doing it. And again, counterparts are allowed in some other jurisdictions, which would make it a lot simpler, I think. But we have to have one document that's signed by everyone in ink, which creates logistical issues, I think, particularly if, as I mentioned, the testator does die during the process, and then you have a will which hasn't been validly executed under the Wills Act as amended. So it's it would create all sorts of problems, I think. So
yes, and also people are a little bit germ-phobic at the moment.
They are with
up the actual document that
exactly, and there's
the
the practicalities actually of transporting it. Of course, I mean, at the moment we're not, we're in a restrictions apply, but of course there are quite considerable restrictions in certain parts of the country. Certainly in the northeast, there's restrictions have been tightened in the last couple of days. So, and certainly in a full lockdown situation, as we were unfortunately experiencing back in sort of March, April time, the actual physical transporting of documents would be problematic in itself. So I think the statutory instrument should have probably gone a bit further and been a little bit more innovative. As I said, it's very limited in its scope, and I think allowing, for example, counterparts and allowing expressly the testator to direct one of the witnesses to sign on their behalf would have been sensible, in my opinion. But unfortunately, the legislation doesn't go that far. So it's sort of, it doesn't quite go far enough in my view.
Brilliant. Luke, on that note, what do you think about our poll, which seems to indicate a 50-50?
We have. I'm rather surprised, to be honest with you. I actually thought that video witnessing of wills is something that's probably here to stay. Perhaps, as I said, I think the legislation itself needs to be perfected and amended again, because I don't think the current SI does the job sufficiently well. But certainly, in terms of the future video witnessing of wills, electronic signatures, I think they're going to be here to stay, personally, because I think that's something that people will get used to.
It's private client lawyers that we like our ink, I think. We think about ink. Anyway, it's been a wonderful morning. Thank you very much, both of our speakers, Oliver and Luke, as ever. Fascinating talk and very interesting chat afterwards. We've come to the end of the webinar this morning. Thank you everybody who's come, and we will send the slides to you tomorrow. Thank you for attending, and please do let us know. Please do let us have some feedback if there's anything that you would like us to put on for our next webinar, which will probably be in a couple of months' time. Thank you everybody for listening. All the very best.
Thank you.
Goodbye.
Goodbye.
Bye.